at 4:47 p.m. Eastern Standard Time. This afternoon, only a few hours after Canadian Prime Minister Mark Carney carefully demonstrated that President Trump had misrepresented the U.S. Canada crisis during a globally televised fact-check watched by more than 1.2 billion viewers. A dramatic development unfolded. At the same time, the United States Congress was preparing to vote the next morning on overriding Trump's second veto of the implementation legislation. In response to the escalating situation, Carney activated a rarely discussed provision of international trade law, one that many legal analysts believed had been essentially dormant for decades. Carney officially informed the World Trade Organization that Canada was invoking Article 21 of the General Agreement on Tariffs and Trade, widely known as the Security Exception Clause. This clause allows any WTO member to suspend its trade obligations toward another member if that member's behavior is considered a threat to the country's essential national security interests. By invoking Article 21, Canada declared that the actions of the United States now represent a threat to Canadian national security. As a result, Canada announced the suspension of all WTO obligations related to trade with the United States. This declaration carries enormous implications. It effectively means that Canada is no longer bound by the international trade framework that normally governs economic relations with the United States. In practical terms, Canada can now impose unlimited tariffs on American goods, prohibit imports from the United States entirely, nationalize U.S. corporate assets operating within Canada, and even refuse to recognize American intellectual property protections. The entire legal structure that typically limits such actions simply no longer applies to U.S. Canada trade once Article 21 has been invoked. Historically, Article 21 has been used only a few times in the 77-year history of GATT and the WTO, and almost always during situations involving actual military conflict or the immediate threat of war. Canada has now invoked it against its closest ally, its largest trading partner, and another democratic nation. By doing so, Canada has essentially declared that its economic relationship with the United States will now operate under a legal framework similar to those used during wartime conditions. President Trump reportedly believed he could ignore the congressional override legislation and continue issuing demands. Carney, however, activated a legal mechanism that grants Canada extremely broad economic powers under international law. Once this mechanism is in effect, there is virtually no legal route within the WTO system for the United States to reverse it. In other words, Canada now possesses an unprecedented level of economic leverage. In this breakdown, we will examine exactly what Article 21 allows Canada to do, and why it is widely considered one of the most powerful legal tools in international trade law. We will also look at the immediate reaction from global trade institutions, the stance taken by the WTO, and why several major economies appear to be supporting Canada's position. Additionally, we will explore what happened in Washington when officials realized that Canada now has the legal authority to take economic actions without being constrained by WTO rules. We will also explain why Article 21 has never previously been used against a major trading partner in this way, and why Canada's decision could establish a precedent that may reshape global trade dynamics. Finally, we will discuss 3 possible scenarios that could unfold now that Canada is operating under this expanded authority. If you find this analysis valuable, consider subscribing and sharing the video so others can follow the developments as well. To fully understand the significance of this moment, it's important to look at the wording of Article 21 itself. The provision, titled Security Exceptions, states that nothing in the agreement should prevent a contracting party from taking any action it considers necessary to protect its essential security interests. These interests may relate to matters such as fissionable materials, arms and military equipment, or actions taken during times of war, or other serious international emergencies. The critical phrase within the article is any action which it considers necessary for the protection of its essential security interests. Under this language, if a country determines that its national security is at risk, it can take actions that would otherwise violate WTO rules. Importantly, the determination of what constitutes a security threat is huriyun, self-judging, meaning the country invoking Article 21 decides for itself whether the threat exists. In Canada's formal notice to the WTO, the government stated that it was invoking Article 21 because it determined that several actions by the United States posed a threat to Canadian security. These actions included alleged violations of bilateral trade agreements, statements viewed as threats to Canadian sovereignty and territorial integrity, economic pressure intended to force policy changes, the suspension or threatened termination of defense cooperation agreements, and the refusal to implement commitments approved by the United States Congress. Because of these factors, Canada announced that it would suspend all obligations under GATT and WTO agreements related to trade with the United States. Effective immediately. Canada also reserved the right to take any measures it considers necessary to defend its security interests without being restricted by international trade rules. In practical terms, this means that many of the principles that normally govern trade between the two countries no longer apply. For example, the most favored nation principle, which requires countries to treat all WTO members equally, no longer binds Canada in relation to U.S. goods. Canada could offer favorable trade terms to other countries while imposing restrictions specifically on American products. Similarly, the national treatment principle, which normally requires foreign goods to be treated the same as domestic products once they enter a market, is no longer applicable in Canada's trade with the United States. Canada could legally prioritize Canadian-made products over American imports in its domestic market. Tariff limits that normally cap how high duties can be raised are also suspended. Canada could impose tariffs of 100%, 500%, or even higher too, on selected U.S. products if it chooses. Restrictions that normally prevent countries from banning imports entirely would also no longer apply, meaning Canada could block American goods from entering its market. Intellectual property rules could also be affected. Canada would have the legal authority to suspend recognition of U.S. patents, trademarks, or copyrights in certain circumstances. In theory, Canadian companies could produce goods using American technology without paying licensing fees, though such steps would likely be politically controversial. Other WTO rules governing subsidies and investment protections could also be bypassed. Canada could subsidize domestic industries without limit to strengthen them against American competitors. It could also review or even nationalize certain U.S.-owned assets within Canada if it believed those actions were necessary to protect its security interests. In essence, invoking Article 21 opens the door for Canada to conduct a form of total economic confrontation with the United States within the boundaries of international law. That is why the move has captured the attention of governments, economists, and trade experts around the world. Shortly after Canada submitted its notification, reactions began emerging across the global trade community. Within minutes, the WTO acknowledged receiving the notice and stated that Article 21 is a legitimate provision, recognizing that nations have the sovereign right to protect their security. While the WTO noted that such invocations are rare, it also confirmed that member states have the authority to determine for themselves when their security interests are threatened. As the evening progressed, several major economies issued statements indicating that they would not challenge Canada's legal position. Some expressed understanding of Canada's decision, while others emphasized that Article 21 exists precisely for situations in which countries believe their security is at risk in international relations. Meanwhile, officials in Washington reportedly held urgent discussions after learning of Canada's decision. Trade representatives and legal advisors examined whether the United States could challenge the move through WTO dispute mechanisms. However, because Article 21 is widely considered self-judging, Most experts concluded that there is little legal ground to overturn such a decision once a country invokes it. Senior officials from departments including Treasury, Commerce, and the State Department reportedly discussed the potential economic consequences. Concerns were raised that if Canada imposed severe tariffs or blocked imports, American exporters could lose access to one of their largest foreign markets. There were also warnings that a broader precedent might encourage other nations to adopt similar measures if they perceived security concerns in their trade relationships with the United States. Later in the evening, Carney addressed the situation in a press conference. He explained that Article 21 was included in the GATT framework precisely because its architects understood that international relations can deteriorate to a point where normal trade rules no longer function effectively. According to Carney, when agreements are violated and a country's sovereignty is challenged, governments must retain the legal authority to protect themselves. At the same time, Carney emphasized that Canada does not intend to misuse this authority. He stated that Canada is not planning to impose extreme tariffs or completely ban American imports at this stage. Instead, the goal is to ensure that Canada cannot be pressured economically in the future. Carney also suggested that if the United States fully implements the commitments previously approved by Congress and demonstrates reliability over time, Canada could eventually consider restoring its WTO trade obligations with the United States. However, he made it clear that any restoration would depend on future behavior. Within hours, Canada announced its first measures under the authority of Article 21. U.S. companies operating in Canada were instructed to register with the Canadian government and provide detailed information regarding their operations, ownership structures, and financial connections. Officials said the step would help Canada monitor economic activities that could potentially affect its security interests. Additional measures followed, including the creation of a Strategic Industries Protection Board that will review any transfer of sensitive Canadian technologies or resources to U.S. entities. Such oversight mechanisms would normally face challenges under WTO non-discrimination rules, but Article 21 provides the legal basis for these actions. Trade law experts quickly began describing the situation as one of the most significant developments in international trade governance since the creation of the WTO in 1995. If Canada's invocation of Article 21 remains unchallenged, as many expect, it could expand how the provision is interpreted in the future. Historically, Article 21 was used in situations involving direct military threats or armed conflict. Canada's use of it in response to economic and political tensions represents a much broader interpretation. If other countries follow the same approach, the scope of the security exception could expand dramatically. This raises an important question. What happens next? Analysts are now considering several possible scenarios. In one scenario, political pressure within the United States leads to rapid compliance with congressional requirements, reducing tensions and allowing Canada to eventually suspend its Article 21 measures. A second scenario involves a prolonged period of limited restrictions, where Canada maintains the authority granted by Article 21, but applies it selectively rather than escalating into full economic confrontation. A third scenario, considered the most dramatic, would see other major economies invoking Article 21 in their own disputes with the United States. If multiple countries followed Canada's example, the global trading system could begin to fragment, with security exceptions replacing the traditional rules-based framework. For now, one fact is clear. Carney has triggered Article 21, and the implications are being watched closely around the world. Canada now has the legal authority to take economic actions against the United States without the normal WTO constraints. Washington is assessing its options, global markets are paying attention, and the future of the rules-based trading system may depend on how events unfold in the coming days.